This is a study guide on fraud. Fraud requires a knowing misrepresentation of a fact. It is an intentional tort, so it must be a knowing misrepresentation. The person making the misrepresentation must know that it is false when it is made. The party making the false statement must intend for the victim to rely upon the fact, the misrepresentation, and the party receiving the misrepresentation must actually rely upon that fact to their detriment or causing injury to the innocent party. There are two main forms of reliance: justifiable reliance, which is the majority rule, and reasonable reliance, which is the minority rule. Alabama employs the reasonable reliance standard. The basic difference between the two forms of reliance: both are forms of reliance on the misrepresentation, which results in injury being caused to the victim. In the first instance, for justifiable reliance, which is the majority rule, but it is not the rule employed in Alabama, a person may be justified in relying upon the verbal misrepresentation of an agent of a company, even if there is something in writing that contradicts it. Example, you're purchasing a car at an automobile dealership. The salesman informs you that the car has never been wrecked. Somewhere in the writings, somewhere in the contracts, there is a provision that contradicts that. Either that the car has not, or there's no representation being made that whether the car has been wrecked or not, or that the purchaser agrees and acknowledges that no representation has been made at all. Using the justifiable reliance standard, the law says that the party is justified in relying upon the misrepresentation made by the agent verbally, even though there's something in writing that contradicts it. If, on the other hand, the reliance standard being used in the particular jurisdiction is reasonable reliance, which is the rule in Alabama, the law is that it is not reasonable to rely upon a verbal statement or a verbal misrepresentation made by an agent if there is something in writing that contradicts it. In the event of a lawsuit in the example I just gave concerning the automobile dealership that sold a car that had been wrecked, even though the sales agent had represented that the car had never been wrecked, since there was something in writing that contradicted it, it wasn't reasonable for the plaintiff to rely upon that misrepresentation, and as such, the elements of fraud have not been met. Thank you.